Good afternoon. Attorney Protective would like to welcome you to today's webinar, Better Safe Than Sorry, Tips to Prevent Conflict of Interest Violations, Erin McCartney and Calhoun Watson. With that, I would like to introduce your first speaker, Erin.
Great. Well, thank you so much, Michelle. Conflicts of interest present some of the most frequent, difficult, and dangerous problems confronting lawyers. The problems are common because lawyers must screen for possible conflicts of interest with every new client. The problems are difficult because the ethics rules are complex and confusing. According to a recent study, year after year, conflict of interest continues to be one of the most common alleged legal malpractice errors. Conflicts are a growing concern today since the global pandemic has changed the traditional legal landscape. Over the past 2 years, law firms have had to adjust to ever-changing circumstances and client expectations. The effects of the pandemic have also placed more financial pressure on lawyers. To be honest, it still remains unknown, at least with any degree of certainty, just how the pandemic will impact claims against attorneys going forward. But we know that historically, economic pressures have led to a greater number of claims against lawyers as clients look to point fingers for commercial or other setbacks, whether warranted or not. We will begin our presentation by discussing the applicable model rules addressing conflicts of interest, but before we do that, I would like to quickly look at slide 4. Ames & Goff, a specialty insurance broker, has issued the results of its latest survey on legal malpractice claims with 9 leading lawyers' professional insurers. As you can see, the survey data confirmed that conflicts of interest continue to be the most commonly alleged legal malpractice error. Legal malpractice cases alleging a conflict of interest can be very difficult and very expensive to defend. And this is because the underlying theory of a conflict of interest, that a lawyer or a firm did not maintain loyalty to clients, typically does not sit well with the jury. Juries sometimes find in favor of plaintiffs even where law firms have followed the requirements of the rules of professional conduct and where they handled potential or actual conflicts in accordance with those rules. In some jurisdictions, punitive damages can be awarded in a legal malpractice action based on a conflict of interest. Conflicts are a growing concern today as increasing numbers of law firms seize opportunities for growth and expansion, either through mergers and acquisitions or by bringing in lateral hires. So I think looking at this data and knowing the difficulties and the high cost to defend a conflict of interest claim demonstrates why it's important to understand and to be able to spot conflicts out of the gate. We will begin our presentation by discussing the applicable model rules addressing conflicts of interest. And with that, I'll turn it over to Cal. Cal?
Thank you, Erin, and thank you for including me in this webinar today. Let me begin by saying my perspective today is litigation. I am a litigator, but the same rules that we talk about that apply to litigation apply to all other practice areas, no matter what practice area you might be in. Also, I think it's important to know that all of the states and D.C. have adopted the model rules of professional conduct. It's important, though, that you check your particular state's rules or whatever jurisdiction you're practicing in. In many instances, states add or revise the model rules to reflect some sort of local practice or custom that might be unique to that jurisdiction. I practice in South Carolina, and the South Carolina rules that are the counterpart to model rules 1.8 and 1.10 both add a couple of additional requirements for South Carolina practitioners. The South Carolina rules of professional conduct also have a couple of additional rules that aren't contained in the model rules, and the model rules have at least one rule that's not included in the South Carolina rules. So it's important that you check your local jurisdiction. As Erin said, I'll talk briefly about what rules are at play and highlight some of the important requirements for all of us to consider. We'll look at some scenarios a little later in the webinar, and these scenarios will help show us and illustrate how all of these rules work together in the real world. So what rules are important to our topic today? Well, if you haven't done it already, it's worth a few minutes to scan the index of the rules of your jurisdiction. And if you do that, you'll see that the first 19 or 20 rules deal with the overall client-lawyer relationship. And this is the section where we find the specific rules that deal with conflicts of interest. Specifically, rules 1.7 through 1.12 and 1.18 all deal with conflicts. This includes how you identify conflict and how the conflict can be waived or resolved, if it can be at all. I'd encourage you also to look at Rule 1.0, which is the definition rule. And in the rules we talk about today, you will hear me say, and you'll see if you read them, the terms informed consent, reasonable belief, writing or written, and consult or consultation, among others. And these words and phrases are defined in Rule 1.0. So as you take a look at the pertinent rules, don't forget the definitions, because these definitions can give you a good bit of guidance and may also impact the outcome of your analysis. Now, the rules themselves are divided into several sections. Rules 1.7 and 1.8 are the rules that generally address conflicts that arise with current clients. Rule 1.7 is the general rule, and 1.8 deals with specific situations. And we'll see some of those specific situations in the scenarios that we'll discuss in a few minutes. But Rule 1.7 addresses when a conflict exists in very broad terms. And the definition in 1.7 is really important because it's the foundation for the rest of any analysis you go through, and everything else in the rule builds off the definition in 1.7. And what Rule 1.7a says is that a conflict exists when the representation of one client is directly adverse to another client, or the representation of the client will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by the personal interest of the lawyer. And the second part of Rule 1.7, 1.7b, deals with whether a conflict can be waived. I'll be speaking in detail on that issue in a few minutes, and we'll also deal with waiver when we discuss the scenarios. Rule 1.8 takes the analysis one step further and looks at more specific issues such as going into business with a client, soliciting a gift from a client, guidance on who can pay the lawyer or whether a lawyer can provide financial assistance to a client. And throughout this rule, you'll see the terms I mentioned a minute ago: informed consent, substantial, reasonable. And as I said, remember to keep those definitions in mind and make sure that your understanding of what these words mean is consistent with the definitions that are in Rule 1.0. The situations you'll find in Rule 1.8 are not issues that arise every day. In fact, you may or may not ever find yourself in any of these specific situations. But when you do, Rule 1.8 is the go-to rule to help lawyers address and navigate these very particular and specific situations. Let's move to the next slide, and we'll talk about Rule 1.9. 1.9 addresses duties to former clients, and these are duties that are different from the duties that we owe to current clients that are addressed in Rules 1.7 and 1.8. And the distinction is really important. The duties owed to a current client are different, as I said, than the duties you owe to a former client, and we'll see that in practice when we discuss the scenarios in just a few minutes. The key phrase in Rule 1.9 is the phrase same or substantially related matter. So if you've represented a client in the past, you cannot later represent a current client in a matter which is the same or substantially related, and in which the current client's interests are materially adverse to the former client unless you have informed consent in writing. And a key to informed consent is writing. It must be in writing. Again, I'll speak a little bit further about this rule in a moment, but for now, remember that the phrase same or substantially related matter is very important. And this is further discussed in a comment, I think it's comment 3 to Rule 1.9, to help us define or understand what same or substantially related matter means. Rules 1.10, 1.11, and 1.12 all deal with imputing conflicts among lawyers who practice together as a firm. And believe it or not, the word firm is also defined by Rule 1.0. We'll deal with imputing conflicts in more detail when we discuss the scenarios, but just understand that that's where these rules are in the lineup. And it's also important to look at all three of these rules together, because otherwise things can become easily become confusing. For example, looking at Rule 1.10, Paragraph A operates only among the lawyers currently associated in the firm. When a lawyer moves from one firm to another, that scenario is governed by Rule 1.10b. And when a lawyer joins a private firm after having represented the government, imputation is governed by Rule 1.11b and c, but not Rule 1.10. So you can see these rules can be very technical, so it's wise to review this set of rules when lawyers join your firm or when lawyers leave your firm. As far as the rules among lawyers currently associated together, it's a good idea to read the rule, but the basic premise is that a firm of lawyers is essentially one lawyer for purposes of the rules, and that each lawyer is vicariously bound by the obligation of loyalty the other lawyers in the firm owe to their client. Briefly, Rule 1.12 deals with situations when a former judge or law clerk joins your firm. That rule also includes arbitrators, mediators, and any other third-party neutrals. And the last rule we'll look at today is Rule 1.18, and this addresses duties to prospective clients. Prospective clients are people who discuss with the lawyer the possibility of forming a lawyer-client relationship. But for any number of reasons, prospective clients do not always become current clients. Even if they don't become clients, but they've shared information with the lawyer, this information under certain circumstances is protected. And as you'll note from this rule, prospective clients receive some but not all of the protections afforded to the clients. This rule gives you a roadmap to follow in the event this issue arises, and we'll talk again a little more about this rule when we discuss the scenarios in a few minutes. But speaking of scenarios, I'll now turn it back over to Erin.
Great. Thanks, Cal. Thanks for that overview of the rules. Well, now let's shift our focus to some common scenarios that we are seeing in the current legal arena regarding these rules. We will then discuss some lessons learned and then best practices related to the topics. So our first scenario, many lawyers are married to lawyers, socialize with other lawyers, and count lawyers that they have interacted with on a professional level for years as friends. So when do these relationships create conflicts of interest that require lawyers to take steps to address the conflict? According to a new ethics opinion from the ABA's Standing Committee on Ethics and Professional Responsibility, lawyers' personal relationships with opposing counsel may create a conflict under the rules of professional conduct. As Cal advised, Model Rule 1.7 prohibits lawyers from representing a client if there is a significant risk that the lawyer's representation will be materially limited by a personal interest of the lawyer. For example, a lawyer's independent judgment is likely to be materially limited if, due to the personal relationship with opposing counsel, the lawyer would refrain from filing a well-founded motion for sanctions against opposing counsel. Comment 11 to Model Rule 1.7 specifically identifies such a personal interest as when a lawyer is closely related by blood or marriage to opposing counsel. In such a case, the attorneys cannot handle the client's case unless each client has given informed consent confirmed in writing. This recent ethics opinion takes this comment one step further. It explains that other personal relationships, aside from marriage, can create a conflict for lawyers. The opinion analyzes three categories of relationships: intimate relationships, friendships, and acquaintances. According to the opinion, lawyers in intimate relationships with other opposing counsel or lawyers who are close friends with opposing counsel must disclose such relationships to their clients and often must obtain the informed consent of clients confirmed in writing, or they cannot represent the client. It also states that lawyers who cohabit in an intimate relationship should be treated similarly to married couples for conflict purposes. This includes those who are married, engaged to be married, or in exclusive intimate relationships. In these instances, lawyers must disclose the relationship to their respective clients and may not represent the client unless each has given informed consent confirmed in writing. As an example, where an assistant district attorney is in an intimate relationship with a criminal defense attorney, the two may not represent adversaries in a matter absent informed consent. In the case of the assistant district attorney, this would most likely mean obtaining approval from an appropriate government supervisor. As for friendships, the opinion says those may be the most difficult category to navigate. Close friendships with opposing counsel should be disclosed to clients, according to the opinion. These include friendships in which lawyers exchange gifts at holidays or spend time routinely at each other's home or vacation together with their families. However, opposing counsel who were once law school classmates, who were once, they practiced together, but don't necessarily see each other regularly, they ordinarily do not have to obtain clients' informed consent and may not have to even disclose the relationship to clients. So in summary, the analysis really turns on the closeness of the friendship. Now, acquaintances. The third category discussed are acquaintances. The opinion describes such relationship as those in which individuals see each other at gatherings, such as professional organizations or even church, but don't feel a close personal bond. Lawyers who are acquaintances of opposing counsel do not need to disclose the relationship to clients, although the lawyer may choose to do so. So a best practice tip here is when handling a matter, lawyers should examine the nature of their relationship with opposing counsel in case there is a conflict or a relationship that appears to be close enough to require disclosure and client consent. Despite this opinion, the distinctions between these three categories, they still have ambiguities. So disclosure may be advisable to maintain good client relationships regardless. It may be helpful to inform the client that you have a professional connection with the opposing counsel and then explain how it will not affect or limit your objectivity. And it may, in fact, assist in the representation because the lawyers can work together collegially. Before we move on to our next scenario, Cal, is there anything you would want to add here?
Yeah, I would just say that especially in smaller bars, this issue comes up frequently. Frequently, the other lawyer and may have been a classmate or a church mate or neighbor. And I think my experience has been the clients like the fact that you have a good relationship or a relationship with opposing counsel. I typically let a client know if I have some sort of relationship with the other side.
Great. Thanks, Cal. Okay, moving on to our next scenario. There is no doubt that the practice of lawyers investing in clients has become more common in recent years and has been led largely by firms representing high-tech clients. But even when precautions are taken, lawyers are still at risk at being accused of self-dealing. The lawyer who goes into business with a client faces a heavy burden of establishing both informed consent and transactional fairness. Investing in clients' businesses also falls into the class of conflicts involving personal, financial, or business interests of the lawyer that may conflict with those of the client. A good economy and healthy corporate profits do not typically foster an increase in malpractice claims. However, as we discussed earlier, when we see an economic downturn and falling profits, we see a rise in these types of conflict claims. So what are the risks that such investments can create, and are they worth taking? Rule 1.8a generally permits attorneys to invest in their clients or enter into such business transactions if three general requirements are met. One, the terms of the transaction are fair and reasonable to the client and disclosed in writing. And keep in mind that whether the transaction's terms are fair and reasonable to the client's interests will often be viewed from the perspective of the client. And that's because there can be an appearance in such a situation that the attorney is placing his financial interest above the interest of the client, potentially creating a conflict. Two, the client is informed of and given the chance to seek independent counsel regarding the transaction. Independent counsel operating with no interest in the transaction allows the client to benefit from professional judgment free from conflict, and additionally adds to the likelihood that the agreement will pass muster in the future. 3, the client provides written, informed consent to the essential terms of the transaction and the lawyer's role in the transaction. Like all conflicts of interest, obtaining a client's informed consent to an investment by an attorney typically involves more than just reporting that a conflict might exist. Many attorneys will ensure that the client's actual consent is disclosed in writing. In practical terms, this may mean that the client signs the disclosure with a sentence added that states that the client has been informed of the risks, advantages, disadvantages, alternatives, and information necessary to assess the transaction and affirmatively and expressly consents to the transaction. One additional precaution that some will take is the addition of a witness to the client's signature. The most important goal is to eliminate any dispute regarding the client's consent to the transaction. The question that will ultimately be presented to a jury in these type of situations is whether the lawyer's investment stake was sufficient enough from the lawyer's point of view to impair his or her objectivity. In my own experience with handling legal malpractice claims over the years, I've seen many fallouts when attorneys do business with clients. While clients often invite lawyers to invest with them, lawyers should be very careful and comply with the requirements of Rule 1.8. The current rules don't prohibit a lawyer from engaging in business dealings with a client, but doing business with clients is discouraged and restricted by this rule. And this is because a lawyer's legal skill and training, together with the relationship of trust and confidence between the lawyer and the client, it creates the possibility of overreaching when the lawyer participates in a business, property, or financial transaction with a client. Failure to comply completely with all of these requirements may result in the lawyer's suspension or disbarment, even if the deal is to the client's benefit. Although ethically permissible if the conditions are met, from a risk management perspective, entering into a business transaction with a client is not necessarily a good idea. Cal, is there anything you would want to add to investing in clients?
No, I would agree. There are a lot of pitfalls. It's probably not worth the risk, but if there is a situation, I would definitely keep in mind 1.8A2, and that's the opportunity to seek the advice of independent legal counsel. I think if the client has another lawyer looking at that client's interests and negotiating whatever the investment is, I think that's the best safety net you could have. But again, there are a lot of pitfalls. I would stay away from it personally.
Yeah, I agree. All right, great. Moving on to our next scenario. So this one is dealing with social media and technology conflicts. The interactive nature of social media, inviting and responding to comments to a blog post, or engaging in Twitter conversations, or even responding to legal questions posted by users on a message board, it creates a real risk of inadvertently forming an attorney-client relationship, which comes with all the malpractice exposure when you haven't even been hired or paid or even had the chance to run a conflicts check yet. For example, if a person asks a legal question on a social media platform and a lawyer answers or says that he or she will look into it, a lawyer-client relationship may result regardless of a signed engagement letter or even a formal handshake. This can create a serious conflict problem for a lawyer. While it may not seem fair, because you're an attorney, you run the risk of creating an unintended client relationship wherever you go. I know with me, I've had people and friends of friends not only do this at in-person social functions, but also reach out to me via social media with, "I know you're a lawyer. I have a real quick legal question for you." If this happens to you, you should hear my voice in the back of your head reminding you that in these conversations, you need to be concerned about the possibility of conflicts of interest. What if you or your firm has represented an adverse party? And how would you even know without first learning information about the issue, information that could very well disqualify you from your current case? Depending upon the ethics rules in your jurisdiction where the communication takes place, use of appropriate disclaimers in a lawyer's or a law firm's social media profile or in connection with specific posts may help avoid inadvertently creating this attorney-client relationship so long as the lawyer or the law firm's online conduct is consistent with the disclaimer. To avoid incurring unwanted obligations to prospective clients, lawyers should either discourage unilateral emails or urge would-be clients to avoid communicating sensitive information until the lawyer has done a conflicts check. These precautions can be taken both in general advertising and on the lawyer's website. So a best practice tip here is when using social media, attorneys should not only speak in generalized terms, but also post explicit disclaimers stating that any interaction does not form an attorney-client relationship in order to inform the user and ultimately rebut any reasonable belief that one exists. Shifting gears just a bit here, I want to point out that on your slide you will see a DC opinion listed. I thought this was interesting when discussing conflicts in social media because it discusses how expressing your opinion via social media can also create a conflict. We currently live in a very polarizing political world, so if you like a political Facebook post or tweet a comment on a controversial legal topic, are you potentially creating an ethical conflict of interest with your clients who may have contrary interests? The District of Columbia Bar Ethics Committee thinks so. It's one of the first ethics committees to single out blogging, tweeting, or commenting as having the potential to raise a positional conflict with the client. Such a conflict can arise when a lawyer takes one position and then takes an inconsistent position on behalf of the client. The DC committee said caution should be exercised when stating positions on issues on social media, as those stated positions could be adverse to the interests of a client, thus inadvertently creating a conflict. Rule 1.7 states an attorney shall not represent a client with respect to a matter if the lawyer's professional judgment on behalf of the client will be or reasonably may be adversely affected by the lawyer's own financial, business, property, or personal interest. Content of social media posts may contain evidence of such conflicts. This DC opinion makes the point that what you say online can put you in an awkward spot with clients or potential clients. Being identified in a high-profile way with a particular position could certainly cause a client to fire you or not hire you. So this is something to keep in mind when sharing on social media sites. Moving on to slide 10. Slide 10 talks about engagement and non-engagement letters, and this is because we just discussed how the formation of an attorney-client relationship is frequently judged from the reasonable perspective of a putative client, not from the subjective or even reasonable belief of a lawyer. And if a lawyer isn't careful, whether in person or social media or via email, someone may inadvertently become an actual client and potentially cause serious conflict issues for a lawyer. So I think it's important to quickly review the importance of the engagement letter and a non-engagement letter here. Your engagement letter sets the parameters of the attorney-client relationship. It's really the single most important document that defines the attorney-client relationship. It's a smart move to use them, even if they're not required in your jurisdiction. It protects both you and the client. It makes the relationship clear to the client. It helps the client to value and take the lawyer's work seriously. And it memorializes the agreement and the scope of the work to be performed in the event that any dispute should arise later. However, they are only as good as they are specific, and there is a hesitancy to invest some time into them. So what needs to be in it? Well, an engagement letter at a minimum covers essentially 5 areas. I'm not going to read through them because I know they're on your slide, but you should review your firm's engagement letters and make sure that these areas are included. There's also a case on your slide that highlights an example of why having a well-crafted engagement letter is so important, so I also encourage you to read that if you have time. In many instances, however, lawyers are not sued by clients, but actually sued by non-clients or by those who are considered by the lawyer to be non-clients, as we've been talking about regarding conflicts with social media and email usage. Without a fee, without a commitment to representation, and sometimes even without having offered any legal advice, an attorney can become the subject of a malpractice suit. And this is because the determination of whether or not an attorney-client relationship exists is based on the client or the non-client's reasonable beliefs and perceptions. And this is where a non-engagement letter can help. A non-engagement letter gives you the opportunity to emphasize that no advice was rendered and that the prospective client should not rely on anything you or a member of your firm said during a preliminary conversation. And this helps to avoid potentially costly misunderstandings later. So they should include things as far as specifically state in the letter that you are not able to accept the case. It's not necessary to give a reason for declining the case, but you may choose to do so if you would like. Avoid commenting on the merits of the case. If you're not taking the time to research and investigate the case, you shouldn't offer an opinion as to its worth. And this is particularly true if you're not skilled in that area of law. And if there are time limits that apply to the case, generally advise that the client should think about these time limitations and that these limitations are applicable. Do not specifically state your calculations for the time limitations. Emphasize that it's imperative to consult with another lawyer immediately. Consider sending a non-engagement letter by certified mail, return receipt requested, and then keep a file of all non-engagement letters in a miscellaneous file. And be sure to enter the information concerning the declined potential client in your conflict system. On slide 11, you'll see a sample of a non-engagement letter. And the reason that I included this is we have a risk management hotline at Attorney Protective, and I get a lot of questions about non-engagement letters and what needs to be in them. So I thought it would be helpful to provide an example. There is a site listed at the bottom of the slide. Sometimes these sites go inactive, so another great resource if you're looking for any communication letters, especially a non-engagement letter related to conflicts of interest, is legalfuel.com. It's a great library of templates for communication letters, so I would encourage you, if you're interested, to look at that site as well. Moving forward to our next scenario, litigation finance. As the nation continues to deal with the effects the pandemic has had on the economy, lawyers and litigants may be looking for ways to protect themselves and their assets. One topic that has been the subject of significant commentary in recent years, and even more so in the throes of this pandemic, has been litigation funding. Initially, most financing was done on a single case litigation. This meant that the provider had to do a deeper due diligence as the risk was all tied up in one case. They needed a high degree of confidence in both the case and the litigating firm before deciding to fund a matter. More recently, these providers have shifted towards funding portfolios of plaintiff litigation. This allows for less risk, easier diligence, and higher levels of funding. The providers in these scenarios will provide a set amount of funding to cover multiple cases with stakes in each case outcome. This obviously mitigates the risk of any one case becoming a loss. Although litigation funding arrangements can take many different forms, in most instances, a third party, such as a litigation funding company, pays a litigant's attorney's fees and other costs in exchange for an interest in the outcome of the lawsuit. Litigation funders assess the strength of litigation as an investment. In this way, litigation funding can provide access to justice for litigants that otherwise couldn't afford it, or can help minimize the risk for litigants by sharing the costs and the risk with a third party. Of course, at the end of the day, the client has to share legal compensation for real loss with third parties who have no connection with the dispute. However, in many cases, compensation would never have been obtained without the funder's help, especially where smaller and less certain claims are concerned. Experts predict that there will be a flurry of litigation funding activity in the aftermath of the pandemic, and this is because clients and law firms alike may be experiencing cash shortages or layoffs as a result of pandemic-related issues. So working with a litigation funder can help ensure that law firms are paid in real time for their work and to help ease the burdens on cash-poor clients to pay legal fees during financial duress. So lawyers should be alert to potential conflicts of interest issues when working with third-party funders. If the law firm has an attorney-client relationship with the funder based on other representations, might benefit financially from a litigation financing agreement between the funder and another client of the firm, anticipates that the funder will finance future cases of the firm, or receives a referral fee from the funder. To assure compliance with conflicts of interest rules, law firms should not accept a referral fee from a litigation funder. Moreover, counsel should carefully consider whether any existing relationship between the law firm and the litigation funder prevents counsel from giving her best advice to the litigants she represents. If so, counsel should either insist that the client seek independent representation or sever its relationship with the funder. If counsel reasonably concludes that she can give her best advice to the client despite the law firm's relationship with the litigation funder, counsel should both disclose the law firm's relationship with the funder in writing to the client, including the potential that the law firm will seek financing from the funder in future cases. And after fully advising the client, secure the client's written consent to the representation, notwithstanding the relationship between the law firm and the funder. An attorney whose client is contemplating litigation financing should also consider what the client may think at the conclusion of the litigation. For example, whether the client is likely to be upset about the percentage of recovery that the funder receives if the litigation is successful. So as we discussed, Model Rules 1.7 and 8 are designed to prevent lawyers from having a conflict of interest with current clients, but a financing arrangement may cause improper conflicts of interest depending on whether the arrangement is between the client and the funder or the firm and the funder. Although the area is certainly controversial, courts are allowing the use of financing agreements, and the American Bar Association has reviewed the issue and concluded that it does not involve any per se ethical violations, but cautions attorneys to be mindful of their professional obligations to clients, including their obligation to maintain confidentiality and avoid conflicts of interest. So moving on to our last scenario, or at least my last scenario before I hand it back over to Cal, we're going to talk about switching firms. As the country begins to slowly emerge from the pandemic, thousands of attorneys will be looking to move to new law firms or create their own, bringing clients with them and creating the potential for conflicts of interest at their new firms. In these changing times, it's more important than ever to avoid conflicts of interest that could lead to disqualification from representation or even malpractice. The rule of imputed conflicts of interest seems to work well in the context of small or mid-sized firms where lawyers within the firm may have direct access to or actual knowledge of confidential information about another's clients. It becomes more problematic in larger firms where, as a practical matter, lawyers within a firm may not have access to confidential information about a client represented by a lawyer in a distant office. That's why, as lateral hiring continues to climb, many jurisdictions now permit the use of ethical screens to cure conflicts that might otherwise disqualify an entire firm. Although historically screening was not allowed, in 2009 the ABA amended the rule, providing a mechanism whereby the lateral hire can be screened from any participation on the matter, thereby removing the imputation of a conflict of interest that could lead to disqualification. So there's certain criteria here, but in summary, it's critical that law firms implement due diligence procedures to ensure that the lateral attorney identifies and reports to the firm all existing clients and/or matters that the lateral attorney is bringing to the firm. The client has consented to the firm's representation, that the proper intake process has been performed for every new client, and that the firm agrees to the scope of representation. A responsible partner is assigned to each incoming matter to supervise the lateral attorney's work, and sufficient file management procedures such as docketing statutes of limitation and issuing timely status reports are all followed. In the case of lateral hires or law firm combinations, it's critical that firms do their due diligence. Conflict checks in these situations require special attention. And the initial checks are usually to spot conflicts. However, even when firms identify potential conflicts, that typically doesn't stop them from pursuing conversations with lateral hires. If a firm intends to approach a client for a waiver, the firm first wants to know if the attorney is someone worth pursuing. We typically see firms go through rounds and rounds of interviews, compile lateral partner questionnaires and business plans, and present offers subject to conflict waivers before they finally approach the client for a waiver or come to the conclusion that it's not worth pursuing. I think firms should take the conflict process much more seriously up front, start the lateral partner hiring process with a conflict check. I think, unfortunately, sometimes these conflicts are addressed very late in the process when the transfer is all but done. And at this late stage, all parties have such a strong desire to complete the transfer that potential conflicts are often ignored or overlooked. So keep in mind when dealing with lateral hires, you don't want to end up in a position in which the firm has to part with two clients, an existing client and the one that came with the new lawyer, as well as potentially facing two malpractice claims. So with that, I'm going to hand it back over to Cal to finish up our scenarios.
All right, let's switch to the next slide. The next few scenarios are very specific fact patterns, and we can see how the rules work in very specific situations. The next scenario, you can read the specifics on your screen, but essentially it involves a situation in which one lawyer is advocating through a board for the preservation of a historic structure. The potential client owns the building and wants to hire the firm to find a way to destroy the building. So in other words, the potential client and the lawyer who serves on the board of the preservation group are in opposite camps and take opposite positions. So what sort of analysis would we do here? I think the first place to look is Rule 1.7. This is not the typical situation where two entities or clients are directly adverse to each other in the same transaction or litigation. Making that assumption, I would submit that this scenario could create a conflict for the lawyer serving on the board of the preservation group because potentially, and I'll use the language of the rule, there is a significant risk that the representation of the building owner would be materially limited by the lawyer's personal interest. And that's what is addressed in Rule 1.7a, subsection 2. So whether the lawyer's personal interest rises to that level that it would materially limit his or her representation is really a case-by-case analysis, but the optics don't look good. So in an abundance of caution, I would decline that representation. But that leads to the question, can a different lawyer in the same firm assume this representation, the same representation? Put another way, if the first lawyer is conflicted by personal interest, would that lawyer's interest be, or personal interest be imputed to another lawyer in the firm? As a general rule, as I mentioned before, a conflict for one lawyer in a firm is a conflict for all lawyers. But Rule 1.10, and that's the rule that talks about imputation, has two exceptions, and one of those exceptions is a conflict created by a lawyer's personal interest, which does not present a significant risk of materially limiting the representation of the client. So depending on the circumstances, this would typically be okay for another lawyer to assume this representation. Erin, do you agree with that?
I do, Cal. Yep.
Okay. Let's look at the next scenario. This is the classic question of whether a lawyer or a law firm can dump one client in favor of a more profitable client. And in this case, as you can see by reading the fact pattern, a one-time small collection case is the only thing standing in the way of a larger, financially lucrative new matter. So as an initial matter, this situation does create a conflict under Rule 1.7 because this firm would represent two clients that are directly adverse to each other in a proceeding, and for purposes of Rule 1.7, it doesn't matter if the representation involves different matters. In this case, though, the conflict can be waived by following the procedure outlined in Rule 1.7b, assuming that all subparts of 1.7b are met, and we talked about this a minute ago in the overview. You should always look at all of the subparts carefully when considering whether a conflict can be waived. But here the two representations are so different, I would submit that this is easily a waivable conflict. As a waivable conflict, these lawyers could then go through the process of a waiver by informed consent in writing. What happens, though, if the client in the small collection case doesn't waive the conflict? One option in that scenario is to seek out a lawyer in a different firm and substitute counsel with the client's consent. A second option is to consider terminating representation pursuant to Rule 1.16. That rule allows a lawyer to withdraw his counsel if the withdrawal can be accomplished without material adverse effect on the interests of the client. Of course, that sort of process would require a motion and permission by the court, and if the court orders that you continue representation, then obviously you have to comply with that. But that's discussed in greater detail in Rule 1.16c and 1.16d. So in short, the easiest path by far is a conflict waiver, or a consent substitution of counsel, but all hope is not lost if neither of these options are available. Erin, what are your thoughts about this one?
I agree. In this scenario, I think you covered everything, but I think this highlights how tricky these rules can be. So I think that you did a great overview of this particular scenario.
Okay, let's move on to the next scenario. This one is a tricky one, and you can read the fact pattern here, but the issue involves using an expert in one case and then opposing the same expert in a different case. In many practice areas, there's such a small pool of experts that choices are sometimes really limited. My gut reaction on this scenario is that there could be a problem if you are limited by how you would either present the expert or cross-examine the expert because of your duties or responsibilities to a different client. And if that limitation meets the standard of Rule 1.7A2, there really could be an issue. For example, suppose you might challenge the expert's credentials or the manner of operation on cross-examination, and if you forego the opportunities to do that because it might impact how you use that same expert in connection with your other client, then that could create that significant risk that representation of one or more clients will be materially limited by a lawyer's responsibilities to another client. I think this scenario really is fact-specific, so it's very difficult to give any sort of blanket answer. And presumably the expert in this case would have notified the other side of his or her association with the first lawyer. But it's food for thought, and it does illustrate the second part of Rule 1.7a. Erin, what's your reaction to this scenario?
I agree. I think this is a very specific one, but I really think it does a great job at showing how Rule 1.7a works. And I've definitely seen this issue come up, so it's definitely something to keep in mind.
Okay. Let's move on to the next slide or the next scenario. And this next scenario involves prospective representation, and I mentioned this in the overview at the beginning of the webinar. In this case, you're discussing or you have discussed a potential client's case in a very general way, no agreement is reached, and then you're later contacted to represent the opposing party. And so this is really the classic case addressed by Rule 1.18. The bottom line here is that you can have a general conversation about a case and then take the other side. What you can't do is receive information from the prospective client that could be significantly harmful to that person in that matter. And that's the reason that you should, as a matter of practice, really receive only general information that you can use to determine whether or not you'll take the case or whether or not a conflict might exist. But even if you do receive disqualifying information, another lawyer in your firm can take the case so long as you are walled off and you are not apportioned any part of the fee, and those details are also discussed in Rule 1.18. Erin, do you agree with that analysis?
I do, and I would just highlight again, only after establishing an attorney-client relationship should confidential information be shared.
That's a good reminder there, too. Let's move on to the next slide. This is the last of the scenarios, and this involves former representation. You can read the facts on the screen, but the rule at play here is Rule 1.9. And in this scenario, a lawyer represents someone in a divorce action, and then 3 years later, the same lawyer is asked to be adverse to a company, and his former client serves on the board of that company. So is this a conflict? I would submit that this is not a conflict. The matter is not the same matter, and it's not substantially related to the divorce action. And the former client is merely on the board of the adverse party and is not an adverse party himself. I really don't see any problems with that sort of representation. But it gets trickier in the second part of the scenario where the facts change and the suit involves a claim against the former client on a guarantee. And in this case, the lawyer should carefully consider whether he or she obtained financial or other information in the divorce that could be used against the former client in the new suit. So if the lawyer obtained this type of information that's not public, Rule 1.9 prohibits a lawyer from using information relating to the representation to the disadvantage of the former client, even if the matters are not related. Again, there's no blanket answer here other than it depends on the specific facts, but the information obtained in the former representation and the passage of time can really have a big impact. A lot can change in 3 years. Again, it's food for thought. Erin, do you agree?
I do. I agree. And I would just add here, when I look at this rule, I've seen issues with continuous representation when the firm thinks the matter is concluded and the client is now considered a former client. Meanwhile, the client believes they're still a current client. So I would just add here a plug for using termination letters. I think absent a formal termination letter, it can be difficult to determine whether the representation has been terminated and therefore whether the client's considered a former or a current one. It's just my 2 cents on that one.
All right. Well, I think what we do now is move into what do you do when you have discovered a conflict of interest. And I think the first step here is that you confirm that you actually have a conflict. And to do that, I'd read the rules that we've gone over today. I'd keep the rules handy. And in today's world, there's no reason you can't have the rules available to you electronically 24/7. They're literally all over the internet. All the bar associations have them on their websites, and they're really widely available. So read the rules, and after you read the rules, if you're still uncertain that a conflict exists, I'd suggest that you look at outside resources. The ABA and many state and local bar associations have tons of resources to help lawyers determine whether a conflict exists. These are things like helplines. Erin mentioned one earlier. Ethics opinions. A lot of the state bars have professional responsibility committees. In addition, all jurisdictions have disciplinary offices that routinely issue opinions, and one of those opinions might apply to your situation. Nearly all of this is now available online and easy to access. If you practice with other lawyers, talk to other lawyers. Some larger law firms have in-house ethics committees that address conflict issues. Don't forget about the comments to your state rules. They're sometimes very specific, and they can be very helpful in determining whether conflicts of interest exist. Typically, I found that a person who is detached with no interest one way or the other can almost always provide a more objective opinion. You just saw through the discussion of the scenarios that conflicts can arise even in circumstances when two clients, other than circumstances when two clients are simply adverse to each other. Keep in mind as you go through the analysis of conflict, of identifying a conflict, that there are business conflicts, there are personal interests of lawyers, there could be new parties later in the litigation. Look at key personnel, look at issue conflicts, former representations. These are all the issues you should really think through as you go through the analysis of whether a conflict exists. If you do all of that and you still can't rule out the existence of a conflict, my advice is to proceed as if a conflict exists. In other words, if you're in doubt, assume you have a conflict. Let's move to the next slide. If you have concluded that you in fact have a conflict, the next step you should go through is to determine whether the conflict can be waived. All conflicts can't be waived, but many conflicts can be waived if certain conditions listed under Rules 1.7b and 1.9 are satisfied. I would, in all cases when you're deciding if a conflict can be waived, I'd read the subparts of these rules carefully, consult the resources I just mentioned, and remember that each of the conditions listed in the rules must be satisfied. This is an and analysis rather than an or analysis. All conditions must be satisfied. And for the most part, you'll see as you go through this analysis that it's based on judgment calls we make as lawyers. Again, as you make judgment calls, the best practice is to resolve all doubts in favor of the client. So, bottom line, in other words, if you have a doubt about whether a conflict exists, you probably have a conflict. If you have a doubt about whether a conflict can be waived, it probably can't be waived. Let's move on to the next slide. If you determine that a conflict exists, you should immediately inform your client. No exceptions. This is rule number one. If you determine that a conflict exists and that it can be waived, you should tell your client that a waivable conflict exists. Most jurisdictions' rules of professional conduct require informed consent in writing for a conflict waiver. So to understand your responsibilities in this situation, make sure you understand how your jurisdiction defines informed consent. Under Model Rule 1.0F, informed consent means the agreement by a person to a proposed course of conduct after the lawyer has communicated reasonably adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. I'd suggest that you read that. Also, Comment 6 to Model Rule 1.0 explains informed consent in greater detail, so I'd take a look at Comment 6 to Model Rule 1.0. So when you obtain informed consent, be sure that you put as much of the communication in writing as possible. It's also wise to advise the client that he or she should obtain independent counsel if they desire to assist in determining whether a conflict can be waived. Let's move on to the next slide. So if a conflict arises because you or somebody in your firm currently represents or formerly represented an adverse party in litigation or a transaction, you should inform opposing counsel and request the waiver from opposing counsel rather than the client themselves. Opposing counsel then can consult the opposing party and determine whether the opposing party is willing to waive the conflict. Again, you need to put as much of the communication with opposing counsel in writing as you can, explain the nature and scope of the conflict clearly and in detail, because you don't want the opposing counsel to waive a conflict and then later claim that you didn't fully disclose the scope or nature of the conflict in the course of your communications. Let's move on to the next slide. Let's say the party refuses to waive the conflict and you're in an ongoing litigation. At this point, you need to inform the court immediately that a conflict has arisen and that you must withdraw from representation. Your client should then move quickly to hire a lawyer to replace you, even if the court grants a longer period of time. After you notify the court, you should make sure that your client is protected from any immediate deadlines. This can be in the form of consulting with the court in writing or reaching some agreement with opposing counsel. Some jurisdictions have fee lien provisions that don't require a lawyer to transfer a file until all outstanding fees are paid, but I think it's a much better practice to immediately transfer all file materials to the new lawyer and consider your accounts receivable with the client a separate issue that you can deal with independent of any conflict analysis. Let's move on to the next slide. If the conflict arises and is not waived before you make an appearance with the court or the matter is not in litigation, you need to immediately decline or terminate your representation in writing immediately. While you should take whatever steps are necessary to protect your client's immediate needs, you need to cease representation as soon as practical. And if you determine that a conflict exists, but going back to the beginning, you determine that that conflict can't be waived, you should skip all the steps we've discussed relating to waiver and simply follow the steps that we just discussed about informing the client and immediately withdrawing or terminating or declining representation. And I can't emphasize enough that speed is very important so that any chance of prejudice to the client is minimized. Erin, do you have thoughts about any of that?
I don't. I think that was a great review of everything. And with that, I'm going to hand it back over to Michelle to open up our Q&A. Michelle?
Let's see. What are the hazards of an attorney entering into a fee agreement on a barter arrangement?
Okay, so I can take this one. Bartering is permitted under most state rules. There are, however, some rules that you need to carefully consider. The first one that comes to mind is Rule 1.5, which says that a lawyer may not charge an unreasonable fee. So you first need to make sure that the value of the legal services that you're providing, that it corresponds with the value of the goods or the services or whatever it is that you're receiving. A fee paid in property instead of money. It also may be subject to the requirements of Rule 1.8, which we talked about today, because this could certainly fall under a business transaction with the client. And if that's the case, then you need to make sure that it's fair and reasonable to the client. There are definitely a few types of barters that are prohibited in most jurisdictions under Rule 1.8. Two that come to mind, the one is prohibiting a lawyer prior to the conclusion of the representation from making an agreement for any literary or media rights to portray any information relating to the representation. And then another one that comes into mind, which probably goes without saying, is the rule that prohibits sexual relations with the client. So you can't bargain for anything like that either. Cal, is there anything you want to add to that question?
Yeah, I think I'd really keep Rule 1.8A in mind. That was the rule that you discussed at great length in one of the scenarios, because depending on what is involved here with a barter, it could implicate that rule. And so all of the caveats that we talked about in that scenario would be at play here, I think.
Thank you. When a conflict exists such that the client must obtain a new attorney, is there an issue with recommending a friend or relative?
I would say that's similar to the scenario that we talked about before with personal relationships. I think the best practice here would be to disclose to your client the nature of the relationship with the person you're referring him or her to, but at the end of the analysis, or the final in the final analysis, I guess, the person receiving the case would have to go through the same conflict analysis independent of the referring attorney. What do you think, Erin?
Yeah, I agree with you, Cal. I'd say there's no issue here as long as you disclose the personal relationship. I think it's a good idea to do so, and of course that you're of the opinion that they're competent to handle the matter.
Thank you both. So just as a reminder, we are past the 60-minute mark. It's not necessary to stay on the line to receive the full credit, but we'll continue. We do have a couple of more questions to share. Let's see. Is a non-engagement letter necessary if you don't give your opinion or if you suggest that the potential client secures other counsel?
I can take this one since we talked about non-engagement letters. I would say, is it necessary? No. As a risk management lawyer, would I advise using one? Yes. A non-engagement letter, as I discussed during the presentation, it gives you the opportunity to emphasize that no advice was rendered and that the prospective client should not rely on anything. They shouldn't rely on you or a member of your firm regarding anything during a preliminary conversation. I think it helps you. It helps avoid a potentially costly misunderstanding later. And these can be short and sweet. Specifically state in the letter you're not able to accept the case. It's not necessary to give a reason for declining the case. You may if you wish. But as a risk management lawyer, I would say it's a good idea to use one of these.
Could you discuss methods law firms use for checking of conflicts of interest, things that work well and things that don't work well?
I'll take this one. I think most law firms, or at least larger law firms, have an electronic way to check for clients in current and prior matters. They can run a search and see what prospective client has been represented before or has been adverse in a previous case. Many law firms also circulate an email or some communication to all the lawyers or all the firm to express the possibility of representation. And I think this is helpful because it catches those things that an electronic search of just the parties to a case just won't catch, like personal interests or business issue or a relationship, all the things we talked about today. So hopefully the people can identify, the lawyers or others in the firm can identify the potential conflicts or potential issues that need to be checked out that aren't identified by the electronic search of just the current and past cases. Now, pitfalls, I think that was part of this question, things that don't work well. I think sometimes people forget to rerun a conflict when an expert is retained or when a new party is added or when something changes substantially in the case during the course of litigation, where I think that firms have to, and lawyers have to be very careful, is to not just run the conflict to start at the beginning of the matter and then drop it and not consider potential conflicts that may arise during the course of the case. Erin, what do you hear from the questions you're asked?
I think your answer was really thorough, Cal.
Is there a reasonable time after which prior representation on a related matter no longer presents a conflict of interest in representing a party opposing that previous client?
I think this is the classic Rule 1.9 analysis because we're talking about a former representation. Rule 1.9 walks you through exactly what the issues are here. I think this really came up in one of my scenarios with the example of representing a client in a divorce and then suing the same client on a guarantee, and the issue became, was the financial information obtained in the divorce materially relevant or would substantially prejudice him in the follow-up case. So I think there is an amount of time that does make a difference, that the longer the time, the more time passes, the less relevant the information will be. But I think in the final analysis, this comes down to the judgment call based upon the facts and circumstances of the particular case.
I agree with you, Cal. I think it does come down to a judgment call. I'm going to go back to what I said in the very beginning of the presentation, that this is why conflicts of interest are tricky. A lot of times the answer is the judgment call. It's not necessarily always black and white. So I would agree with you with that answer.
And even under Rule 1.9, this is a waivable conflict, so you can seek a waiver. But whoever asked this question, read Rule 1.9 because I think it walks you through exactly how to deal with this particular scenario.
Cal and Erin, I'll add one more question on that's an easy one. If you discover that a conflict exists and choose to withdraw from the case, are you obligated to disclose what the conflict is?
I'd say the short answer to that is no. You're not obligated to. You may choose to if you would like, but the short answer to that would be there's no obligation necessarily.
I'd say the short answer and the only answer is no. I think that sometimes the instance of a conflict can be important information and or the nature of the conflict, particularly if there is a conflict. So I think that you are under no obligation to disclose what that conflict is.
Thanks, guys. So that concludes today's event. On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar, and a special thanks to our speakers, Erin and Cal. Everyone have a wonderful day.